Welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a judgment of the Bombay High Court, which has got implications on many cases under the Insolvency and Bankruptcy Code. Now, what does the judgment say? The judgment says that the Enforcement Directorate has to vacate attachment of assets once the company goes under the corporate insolvency resolution process. This is a very important judgment, but this has been delivered. First of all, let me share, it's been delivered by Justice BP Kolabawala and Justice Somashekar Sundaresan, and a very widely appreciated judgment. And we've got an expert today to decode it for us. We have the managing partner of law firm Circle of Counsels, Advocate Karnal Singh, who's an expert on financial crimes. Sir, appreciate your joining us and looking forward to some interesting insights. In the next 5 to 6 minutes, could you share the implications and the judgment with us?
See, first let's understand what was the issue before the High Court. Now the resolution plan was approved by the NCLT under section 31 of IBC code. And NCLT also passed order keeping in view of section 32A of IBC that Enforcement Directorate to release the attached property the corporate debt. That was the order which was in the dispute. What happened thereafter is Enforcement Directorate refused to release the property. The resolution applicant in a writ jurisdiction came to the High Court asking that the adjudicating authority and the Enforcement Directorate be asked to release the property. This is a basic issue. The Enforcement Directorate objected in the High Court that they have alternate remedies. That means a resolution applicant either can go to the appellate tribunal or can move the court to release the property under section 8, part 8 PMLA, Prevention of Money Laundering Act. Now let's understand section 8, part 8, Prevention of Money Laundering Act. It says that at the time of conviction, the property confiscated is given to the government. That means it is vested in the government, and the court can also direct the government to release the property to the victim. It also says that when the trial is going, the court can also release this property. So the ED argument was that they can go to either to the lower court or they can go to the appellate tribunal. They need not have come to the High Court. Secondly, they also claimed against the NCLT that NCLT has no power to interfere in the PMLA. They can only order under IBC. Releasing the property, directing the ED is basically interfering with the PMLA, for which the NCLT has no power. NCLT can only issue order under IBC. So the core issue which Bombay High Court framed was that once the resolution plan has been approved and section 32A comes into play, then can the property which has been attached earlier, that had been attached even prior to the CIRP process has started, can the NCLT issue orders for release of that property? That's a basic core issue in this case. Now, while examining, the High Court went into an understand that what is the section 32A of the IBC. Now, section 32A says very clearly, I'll read part of that. Notwithstanding anything to the contrary, contained in this code or any other law for the time being in force. That is very important. Any other law for the time being in force. The liability of corporate debtor for an offense committed prior to commencement of the corporate insolvency resolution process shall cease, and the corporate debtor shall not be prosecuted for such an offense from the date of resolution plan has been approved by the adjudicating authority under section 31. What does it mean is, if any offense has been done prior to beginning of the CIRP process, that means neither resolution professional nor the new corporate debtor, which would become because the company which we are talking corporate debtor is a company. Now, if the company goes in the hands of somebody else, which are the resolution applicant, and these resolution applicant, section 32A also says that they should not be proxy of the promoters which have caused the fraud or a connected party to them. That means it is entirely independent new party. It is not connected with the people who have committed the fraud. Now, this is a new entity basically. And this new entity cannot be prosecuted. That is the first part of this. The second part of this says that whatever is the property which has been attached prior to beginning of the resolution process should be released. It should not be attached basically. It should not be attached. Now the question is whether NCLT can pass orders to release the property, or whether the resolution applicant has to go to either PMLA appellate tribunal or before the session court for getting the property released. The High Court examined section 31 of IBC. It says that section 31 says that while approving the plan, the NCLT has to ensure the implementation of the plan. Now, the plan cannot be implemented unless the property is released. And therefore, the Bombay High Court came to the conclusion that the order to release the property is basically the part of approval of the plan. Basically, the plan cannot be executed if property is not released. And therefore, the order has been issued under IBC and it has not been issued under PMLA. That is one decision by the Bombay High Court. Then the Bombay High Court has said that once the order has been issued by an authority, by a quasi-judicial body or judicial body, that this property to be released, that it is the duty of the government agencies to release the property. And if they do not release the property, certainly the writ jurisdiction is made out. And there is no need to go for the alternate remedies. It also says that why the resolution applicant, after the resolution application has been approved, should go after the other agencies to get the property released. If the resolution plan has to be executed, the property has to be released. The order has been issued by the NCLT and it has to be executed. That is another aspect why they say the alternate remedy is not required. The court also explained, says once as per section 32A of the IBC, If the prosecution against the debtor cannot be done, the company debtor basically, that is, company debtor is not under prosecution in the court, it cannot be convicted. If it cannot be convicted, the property has to be released. So if the property has to be released ultimately, why the futile exercise of going through the trial process? And therefore, this property must be released. It says once few conditions are there, it has explained the condition. One is that resolution plan has been approved by NCLT. That is number one. Number two, resolution applicant to be unconnected with the people who committed the fraud. And only that property, which is the property of the company debtor, has to be released. Not the property related to other fraudsters to be released. That is not the plan. So that is the judgment. I must explain you one more thing. Because if you go by section 14 of the IBC, through which the CIRP process starts, the moratorium comes into play. Between the section 14 and section 32A, whether properties can be attached or should be attached by enforcement directorate, or the properties which are already already attached by the enforcement directorate before the start of CIRP process, should they be released at the time of beginning of CIRP process? The court has not examined this. Court has only examined after section 32A comes into play. That means when the resolution plan has been approved. Now, what happens in between? And when the CIRP process starts, the property is already attached. Moratorium is there that in this between, property should not be attached. But what happens to the property which has already been attached? See, once the CIRP process starts, we do not know who will be the resolution applicant, in whose favor ultimately resolution plan is passed. Suppose it is passed in favor of the fraudsters or in favor of the people who are proxies to the fraudsters, then certainly section 32A will not come into play. And therefore, between section 14 and section 32A, though the property during this period should not be attached, and that is my view. And if the property has been attached prior to that, it will go to the process of the enforcement directorate until the resolution plan is approved.
A year ago, when you spoke on the show, you echoed these points the attachment of assets and when the IBC process is being undergone.
Yeah, absolutely. I had explained the rationale of IBC PML attachment. The rationale is ultimately victim should be compensated. And if there is no victim, then the property should come vest in the central government. Now the victim in the case of fraud, in the case of company, is basically the creditors. And creditors must be compensated. What is IBC is doing once the resolution plan is passed and the resolution applicant is not connected to the fraudsters? In that case, the victims, which are the creditors, must be compensated. That's the whole plan of the IBC. Now, what is the plan of PMLA? As I explained, section 8, part 8 of PMLA says, either after the conviction or during the trial, the session court can compensate the victim. See, the purpose of both the act is the same. See, ultimately, somebody has been frauded. Somebody has suffered. those people who have been frauded must be compensated. And that is the issue connected with that is the connected with both the acts. And if that is to be connected with both the acts, the IBC provides the restitution to the victims faster if the resolution plan succeeds, as compared to PMLA, which takes more time because the prosecution in our country takes time. It may take 3 years, 4 years, 5 years, and sometimes even 10 years. Should victim wait for such a long period? While in the NCLT process, it can be finalized within 1 or 2 years. And therefore, IBC is a very, very important code, which Government of India has framed to compensate the victims as quickly as possible relating to case of the corporate frauds, where the company is also a victim, company has suffered losses, and therefore company has to be either rejuvenated or company will go in liquidation. In both the case, victim should be compensated. And that's a basic idea of IBC and PMLA both. Therefore, both acts basically point to same thing.
One thing I want to know from you specifically is this judgment of Justice BP Kolabawala and Justice Somashekar and Sundareshan. What impact will it have on the economy and also number of cases? Of course, we understand some of these issues are also being litigated in Supreme Court, where some companies whose assets were attached after having undergone the IBC process, and the new owner is filing in Supreme Court. So, you think it will have a big impact?
Absolutely. See, ultimately, it becomes law of the land. Ultimately, if the Supreme Court comes to a conclusion. But high courts are coming to now conclusions, case after case, that the victims need to be compensated. If the resolution plan has been approved, it has to be executed. The corporate debtor will not be prosecuted, property would be released. And as far as there was a question about the constitutional validity of Section 32A, this has already been upheld by the Supreme Court in Manish Kumar versus Union of India in 2021 case. So Section 32A has been found to be constitutionally valid and it needs to be implemented properly.
So, do you think now this undergoes a challenge before Supreme Court that has to be seen, or do you think this is the last word on this issue?
See, most of the cases and legal issues ultimately get settled in the Supreme Court.
So you mean there will be some more litigation on this issue?
The possibility of some more litigation cannot be ruled out.
But as of now, will parties, companies will be able to take benefit of this judgment, to take benefit and get relief in various courts, High Court and Supreme Court?
Yes, they should try for getting relief.
So if you were to advise, you would say that they can use this as a judgment to seek relief.
Absolutely. There are other judgments also to the same effects by NCLT.
Okay.
And therefore, ultimately, in my opinion, this is the correct interpretation.
Okay.
Subject to any counter by the Honorable Supreme.
One thing I'm happy that 1 year ago, what you shared with us on the show has in one case been upheld by the Bombay High Court. I think 1 year ago, what you said on legally speaking, the judges have found the same in this case and led to the same conclusion. So it is a sense of feeling happy that what we said should happen. A year later, the courts have seen reason in it in some case, and now it has happened. Do you feel happy that this has happened?
Yeah, absolutely. Because the correct interpretation of harmonious construction of various statute is very, very important. And certainly judiciary comes out with that interpretation, gives a correct picture, what is right, what is wrong. And it's absolutely good for the country, good for the people.
So it's taken some time, but it happened.
Absolutely.
Appreciate your joining us, and we end this show on a happy note that some points which you raised 12 months ago were found in it's a vindication of what we spoke about a year ago, that the court saw reason in this case and upheld it. Thank you so much for joining us. Pleasure. Thank you.